So this South African case was, is groundbreaking. It's not just me that says it. For a few reasons, and I can walk you through that if you like.
Yeah, please do. I think it would be really, I mean, I don't really, this idea of connecting the environmental movement with the concept of human rights, I feel that I've seen that play out in particularly, I suppose, Indigenous community kind of contexts, which is interesting. But I guess in the case of South Africa, we're seeing that have a broader applicability. Like, this isn't just it's not about one community or one disadvantaged group. It's like the right to live in a healthy environment is it's a universal human right. Yeah.
So what's really fascinating about this South African case is, they have a constitution. And so within it, Section 24 speaks to all citizens having a right to a clean and healthy environment. And that's what these community groups and environmental groups and lawyers did. Essentially, they used this Section 24 and said, South African government, you have not been looking after us. Essentially, you have not been... Essentially, governments are duty bearers and they have a duty to protect their citizens. So what this group was essentially saying is that, you failed in that we've got air pollution that's significantly harming our health and you haven't been taking necessary actions. And so what this court decided in March 2022 is that they have a very valid case. So they essentially said, yes, as citizens, you have a right to a clean and healthy environment, and the government hasn't been acting, and therefore there's a breach of this right. So that's the first thing to mention. And then it went on and said, the government needs to take decisive action. And this, for me, is quite groundbreaking because the courts essentially put the government on notice, and it said, you've got 6 months to develop some regulations that are stronger, that speak to kind of air pollution, and then you've got 12 months to ensure that they're implemented.
So the timeframes aren't actually, if you think about the consultation that's happening in the UK at the moment, what is it, like a reduction in the sort of limit of PM2.5 by 2040, and the South African government has been given 12 months to get its act together.
Exactly. And they went further and they called out the Environment Minister. They called her by name, Barbara Creasy, and they said, you have to do this. And they actually mentioned in their court case that essentially she'd been dragging her feet. She'd been in
individual. They actually specified her role.
They specified her role. So very much groundbreaking stuff. And then also an important point is that they called on the responsibilities of business. So they said that, in the past, major polluters had kind of ignored or not considered it strongly, that there was this air quality management plan in place. And so this court, essentially the judge said, going, in the future, you need to consider the air quality management plan, and you need to start taking action. You need to start implementing actions to address the air pollution that you're causing. And that's quite significant because governments on the whole are very wary of getting industry to kind of clean up its act. So it's kind of taken that court to say that.
And to really to tackle both, I completely agree. And particularly, the business angle is fascinating to say, you can no longer sort of pay lip service to this, essentially, under your corporate sustainability strategies. This isn't greenwashing. If we're holding people, organisations, institutions to account, then business absolutely is part of that. It's not just a bit player. I think is really that seems really significant, even to someone like me who obviously doesn't really know much about the sector or the history. That does feel like a game changer, specifically in the South African context.